All right, this is case number 21-162-989. This is Damon Banks versus Simpson. The matter is before the court for an adjourned date of hearing. Do I have Damon Banks on the Zoom, please? All right. Do I have on the Zoom Onika Simpson? No. I see some.
Thank you so much. Appreciate it.
All right, either party on Banks versus Simpson. All right, the court will come back to that matter in just a moment. The court now calls case number 21-167-567. This is Beaumont Health versus Sharon Pennington. That is before the court set on for a pretrial conference. Your appearance for Beaumont Hospital, please.
Yes, Your Honor. This is Hal Burke, P69068, attorney for Beaumont Health on this case.
All right, thank you, counsel. And do I have Sharon Pennington on the Zoom? If you're on the Zoom, Ms. Pennington, say something at this time. Sharon Pennington. All right, counsel, I received a note from, looks like Ms. Pennington, and it simply says, sorry, I sent the wrong receipt or something along those lines. And then there's a green card contained therein directed to Mr. Burke at an address in Toledo. All right, counsel, what do you know about this matter?
Your Honor, I will say that is where we're located. I did not receive any note from Ms. Pennington. She is not present. I don't believe she was present at the last hearing. And we have attempted to resolve it short of going in front of you, and we're not successful. With your permission, maybe a default under the 7-day rule would be appropriate. However, I'm happy to defer to you if you think she deserves one more time. Of course, that's up to you.
Thank you, counsel. I think I've said it a couple of times, and I know that Ms. Pennington has raised the issue of the fact that she is on disability, and that she is aware of this matter. I do believe that at this point your request for entry of default is appropriate, and I will allow for the submission of an order for entry of default judgment, and I'll put a 7-day delay on it, but you can submit it right away and send a copy to her. Or wait 7 days before entering the order. So, right. The court finds the defendant is in default, and accordingly will receive a post judgment with a 7-day delay. Counsel, you have an email address for you?
Nothing further. Thank you, Your Honor. Have a great day.
Yeah, you have an email address where you can email the orders to counsel.
Would you mind giving that? I do have it, but I don't have it in front of me. May I please have it again?
Sure that you have it. That's Latifah, Latifah, Latifah. That's Latifah dot, last name is Hunter, at 3636th, 36districtcourt.org.
Thank you, Your Honor.
Thank you, counsel. Good day to you.
Have a great day.
All right, the court calls case number 21-241-240. That's 21-241-240. This is Patrice Robinson versus Bobby Hardison. The matter is before the court on, looks like an application for a claim of appeal from the small claims division of this court. Do I have Patrice Robinson on the Zoom?
Yes. Good morning.
All right, good morning. Good morning to you. Do I have Bobby's towing on the Zoom?
Yes, you do.
All right, so who's here for Bobby Tolling? Bobby Tolling?
Denise Boyce Hardison.
All right, so you own Bobby Tolling?
Yes, I do.
All right, so, all right, I know that this went before the magistrate, some decision was made on this matter. And looks like Bobby's, all right, I'll come back to your matter in just a moment to see where parties are in this regard. So just hang tight. The court now calls case number 17-127383. This is credit acceptance versus Carlisha Ashley, and also versus the garnishee defendant Amazon. The matter is before the court on the following objections to a writ of garnishment. This garnishment arises out of the fact that there was a judgment entered in this matter previously. The total amount of that judgment is $8,689. That judgment was entered on January the 8th of 2018. All right, your appearance for credit acceptance, please.
Good morning, Your Honor. Navjot Francis, P72322, on behalf of Plaintiff's Attorney of Record.
All right, thank you, counsel. Do I have on this Zoom, Carlisha Ashley? If you're on the Zoom, please say something at this time, ma'am.
Yes, I'm here. Good morning.
All right. Good morning to you, Ms. Ashley. Thank you. I see that this has been before the court since 2018. There was previously a partial payment order. That order was set aside previously by the court. And now there is a petition for objections to a writ of garnishment that was issued. You indicate your basis is that you have a bankruptcy proceeding and that therefore this matter should not go forward. Is that correct, ma'am?
Yes.
All right. So you didn't put a bankruptcy case number or anything. So when did you file bankruptcy?
I just recently filed bankruptcy, like maybe 2 weeks ago.
All right. Just one moment. Ms. Francis, have you received any notification in that regard?
No, we have not, Your Honor. Does she have a case number?
Yeah, that was my next question. Now, do you have a case number for your bankruptcy proceeding at this time, Ms. Ashley?
No, not at this moment. I don't.
Well, ma'am, how am I supposed to know that there is a bankruptcy? You got to tell me something. That the bankruptcy would stay this, ma'am. So, you know,
Judge,
go ahead, Ms. Francis.
sorry, I would note on March 29th, after we received defendants' objections, we did check Pacer and did not find a bankruptcy filing.
All right. Are you able to check? Are you able to check that now and see if there's something?
Yes, I can have the
So,
office check, Your Honor.
we're going to try to check, Ms. Ashley, just to see if there is in fact a bankruptcy filing in the system. If there is, then that would stop things for now. But if you don't have a
Yes,
bankruptcy-
I'm sorry, Your Honor. I just recently, like I said, it was maybe 2 weeks ago, I had contacted an attorney and I had set up like a payment arrangement. So I don't know if I have to wait until I'm done paying for it for you guys to see it or not. But I did speak to someone and I didn't get a case number.
Okay, that likely means that your bankruptcy petition has not been filed. That's what that means. They're waiting for you to pay the fees, and then they're going to file your bankruptcy petition. So you don't have any bankruptcy protection right now, ma'am. So you don't have the right to have the garnishment set aside or stayed because you don't have the benefit of bankruptcy protection at this time. I noticed that at a previous time, you were supposed to be paying under partial payment order, and somehow that fell apart. So, you know, I don't see anything where I can stop the garnishment at this time because you don't have the bankruptcy filed as yet. You'll want to let your lawyer know that as soon as he files that, to serve something on the court, and serves it on the court, or serve it on the attorney on the other side, as well as on Netflix, on Next app, whatever. What's the name of your company?
Check the bankruptcy, you're asking about the bankruptcy company?
No, the company that you work for, what is
Next
it?
staff, yes.
All right, so the bankruptcy attorney would have to send a notice to NextApp as well as to credit acceptance, and it would ultimately come to the court as well, and that would stop the garnishment. But without that, you don't have that right now, and so there's nothing here to stop the garnishment. At this time, I would have to conclude that the objections are invalid and that the garnishment will continue under these circumstances. That is my order. I'm signing an order consistent there with at this time. I do wish you well. A good day to you.
Thank you,
Thank
Judge.
you, sorry for you.
The court is called 165-491. This is One Detroit Credit Union versus Jerome Garner. The matter is before the court on the following objections to a writ of garnishment record should reflect regarding this matter that was entered in this case. It looks like the judgment was by consent. It was entered August 29th of 2019. Subsequent to that time, an affidavit of non-compliance was filed with the court indicating that the judgment was not being paid according to the consent agreement. Therefore, the plaintiff now seeks to proceed with regard to garnishment in this regard. All right, your appearance for One Detroit Credit Union, please.
Good morning, Your Honor. Michael T-Man, PA 1102.
All right, thank you, counsel. Good morning to you. Do I have Jerome Gardner on this Zoom? Say something if you're here. Mr. Gardner, Jerome Gardner. Do I have someone regarding Public Service Credit Union? All right, very well. The objections to the writ of garnishment provided that the defendant is not working at this time due to a medical condition. In relationship to the objections to the writ of garnishment, that would not provide a sufficient or a valid reason under the statute for the objection to the writ of garnishment. Accordingly, I would have to find that the objection is invalid at this time. Any funds that are withheld will be released to the plaintiff. Now, I do also see where the defendant filed a petition for partial payments, and the judgment seems to be at some $1,667. The defendant is asking for to allow for payment of $50 per month towards the judgment at this time. Counsel, your position regarding the petition for partial payment, sir.
Good morning, Your Honor. At this time, plaintiff would just suggest that they be denied. One, the defendant hasn't appeared. Two, I'm not completely aware of what's being held by the bank at this time under that garnishment, but there's only right now there's $586 and some change remaining on the judgment after the defendant had made payments in the past. So I think any payment plan should wait until after the garnished funds are released to plaintiff, and then we'll have a better understanding of what, if anything, is left on this.
All right. Yeah, well, it does seem close enough to the bottom. Do you have any idea as to how much money is being withheld by the bank? Did you get a disclosure or something?
I do not, Your Honor. We haven't received the disclosure back yet. It doesn't look like.
Thank you, counsel. All right, Mr. Gardner, if you on the Zoom with Jerome Gardner. All right, it appears the defendant has not appeared regarding this matter. The court may have had some inclination to consider his petition for partial payments. Given the information I've been provided is that the judgment there's a balance in the nature of $600. There may be some money from the Public Service Credit Union. The court is not able to know those things at this time. And moreover, with regard to the application for partial payments, the defendant does not provide any information regarding income, resources, debts, obligations. He simply fills out the form and puts $50 as the amount that he wishes to pay. I don't know if that is reasonable or unreasonable. For all of the reasons set forth in this matter, I will deny the petition for partial payments at this time. The court would certainly take into consideration the same should the defendant repetition the court and provide more information But at this time, the objection, strike that the petition for partial payments will be denied. The objections to the writ of garnishment are found to be invalid, and any funds held will be released to the plaintiff in the sole order at this time. Have a good day, counsel.
All right, yep. Thank you, Your Honor. Have a good day.
The court now calls case number 21-55805. This is Jefferson Capital System LLC versus Wilma Clark. The matters before the court on an application directed on objections to a writ of garnishment regarding Michigan Department of Treasury. This matter arises by virtue of the fact that the judgment was entered by default on October 21st, 2020. The judgment amount on entry was $3,671.40. I see a notice of judgment lien issued on the 17th of February 2021. It appears that there is an outstanding balance, and the plaintiff seeks to recover that balance by the writ of garnishment. There's also a second objection to writ of garnishment with regard to Premier Security Guard, and the objections set forth on both documents not
Well, I see you.
properly
I just talk. Yeah, I can hear you now.
on bill. That's indicated on both document. Does not
We asked you
apply
to unmute.
to defendant not properly
I
owned.
think you need to
All
get
right,
out.
your appearance for Jefferson Capital Systems, please.
Good morning, Your Honor. Jeff Werber, P67124 on behalf of the plaintiff.
Thank you, Mr. Warburton. Good morning to you. I'm looking now for Ms. Wilma J. Clark. Ms. Clark, good morning to you. Say something.
Morning, Judge. How are you?
I'm good. I'm good. I looked at your objections on these matters, and you indicate the property is not your property or something along those lines. What is it? What is the nature of your objection? What are you objecting to, ma'am?
Yes, sir. Good morning. I own the property at 3248 Hazelwood, and I let some relatives move in on January of 2014, and they were not paying the rent on time. So I had just replaced, in November 13th, I had just put all new radiators in the home because somebody had broken the home. It was empty. I had put all new radiators, 8 new radiators in. So I had to put the utilities back in my name. And when they moved in, they were supposed to switch everything back over. And I didn't realize they hadn't, but since they weren't paying, and my husband passed that same year, November 2013. So what I did is I sold the property to them. I have a quick claim deed showing where I sold the property to them, because and his mom, they paid for the property. I got the quick claim deed, and
Okay, let me stop you.
it wasn't my home.
Yeah, let me stop you for a moment, ma'am. Unfortunately, it sounds like, based upon what you're telling me, the bill was in your name, but more importantly, those are issues that you would have had to bring while this case was before the court. That is what you call prejudgment before a determination was made in this case. What you're before the court today for is post-judgment. This is an effort to collect on the judgment that was entered. If you believe that judgment should not have been entered, you'd have to go follow a different procedure. Today,
Okay.
The only thing that's before me today is whether or not the plaintiff, whether or not you have a valid objection, I should say, to their effort to collect money on a judgment that was entered. The judgment was entered all the way back in 2020. I don't have where you responded to the complaint. I have a notice indicating that you were served with the complaint back in September of 2020. You had 21 or 28 days to answer the complaint, and you did, and therefore the judgment was entered by default. That's the problem. That's the underlying problem, is that you have a default judgment against you.
Right.
If you believe there's a basis to have that set aside, then you certainly can file a motion in that regard and try to get that done. But right now you have a judgment against you, and the plaintiff is seeking to collect on that judgment by filing various garnishments. That's the situation that you have today now.
Yes, sir. I never received any service. I've never signed any papers, received any service. I thought this case was ended. It was from 2014. And like I said, I wasn't even on the property anymore. When those, and I did hear from them before, and I even called them and told them, well, I don't own the property. So I did get a release from them saying, I got a release from this Jefferson Capital and they said, so I suppose the people that bought the property from me, they was starting to make payments or made arrangements, because they did send me some notice that I was not obligated. So I had left it alone. It's been a while. I haven't heard anything else from them. I don't know. DT, I didn't even know that until I got this garnishment from my job that they brought it back up again.
Yeah, and you have
I didn't have I would have taken another step, but I didn't know what else to do. I had told them that I didn't own it because, Your Honor, this past January, right before Christmas, I got some money taken from my checking account from some environmental tickets that they had got from the city. They got the money, so I went down to the city and showed them my deed, and they refunded me the $700 this past about a week ago. And that was right before Christmas. I don't own it.
Let me stop you for a moment. I'm glad that worked out for you with the city. This is quite different. You had utilities that were in your name, and these bills approved, and they filed a lawsuit, and they have a judgment against you. If you're gonna go back, you have to go back, and you have to file something to try to get the judgment set aside. But that's not what's in front of you today.
Okay.
Those are issues that you.
What do I need to do? What do I need to do?
Listen, I need you to listen to me now, because I'm getting ready to make my decision. Now,
Okay.
The issue today is a post-judgment issue. That is that there are two garnishments against you based upon a judgment that was entered against you. That judgment was entered because there is a document in the file that shows it's a proof of service that says that on September the 6th of 2020, you were served with the documents at 190 Lakewood. It describes you as a Black female about the age of 66, 5'6" in height. And it indicates that the process served the document on you. Subsequent to that time, that date is when the judgment was entered. It was entered in October of 2020. That judgment is for $3,671.40. After that judgment was entered, that's when the plaintiff started seeking to recover money under that judgment. That's the situation. If for some reason you believe that judgment should not have been entered, you have to file paperwork with the court asking to set it aside, showing reasons why it should not be entered, why it should not be a judgment against you. If what you're saying is that you did have a debt with the utility company and that it was in your name, then you're not likely to get real far with that. If you have, as you say, a document showing that they signed off and said that they waived any obligation that you had, and you want to submit that document with any motion that you may file with the court, because that document would be important here. You got something saying that they waived any debt that they had at some point. Then submitting that document with anything that you filed should be really important in this case. Right now, the only thing that this court can address is the objections to the writ of garnishment, and the basis that you provided on your objection. That's not an objection. That's why you'll notice on the various forms that you filed that it had things like bankruptcy or funds are exempt, or that you have an installment order, et cetera, et cetera. And then it gives you the category of others. That's you really have to have some reason that is based upon the law that would allow you to get the garnishment stopped. And you don't have that at this time. You don't have anything to demonstrate that. So how much money are you expecting from the Department of Treasury now?
The Department of Treasury, I don't know. I probably end up on. I probably end up on because I'm retired from the Detroit Police Department. But Your Honor, they never served me with any papers. I thought this case was over.
Let me stop you, because you want to talk about that over and over again, and then it's going to make me sound like I'm rude by stopping you there.
No, I'm sorry.
I already told you that if you believe that something went wrong, I told you that there's a procedure that you got to follow.
Okay.
Let's tell you about that. I mean, you probably want to talk to a lawyer to see if there's something that you can do in that regard, but there's nothing you can do today, because the only thing that's in today is the garnishment. And
right. And I didn't own the property. When they put their judgment in, even with DTE, I told them that they said they had taken that out of my name.
Let me stop you again.
Okay.
I have other cases to go to. And you probably
all right.
probably noticed these
Okay.
big ears of mine. That's because I hear you the first time around. I
All
heard everything
right,
you said.
all right,
Saying it
okay,
again, saying it
okay.
again doesn't change anything. It does not. Because you said those things, I gave you an explanation of what you probably need to consider going forward. That's all I can tell you about that. Now, as it relates to the objection to the writ of garnishment regarding the state funds, I have to find that the objections are invalid. Any funds that would be withheld would be released to the plaintiff in that regard. Now, I know also that there is a garnishment regarding your wages in this matter. Or so you work for some Premier Security, is that correct, ma'am?
Yes,
All right, so how much money are they taking on the garnishment from you? You get paid bi-weekly or weekly? Which way do you get paid?
I'll be getting paid bi-weekly. I'll be getting paid bi-weekly. They haven't taken any funds. I had put after I did the objection to the garden, they were held to see what was gonna happen at the hearing.
Okay, gotcha. All right, so generally, how much do you take home every 2 weeks?
Probably about, I only work for part-time, probably about $700.
Okay. All right, that's twice a month, right?
Yes,
So your garnishment on that would likely be in the nature of about $210 per pay
oh,
period.
God,
$400
Jesus,
a month.
really?
Are you still talking while I'm talking?
No, I'm sorry.
I mean, you said you retired from the police department or something. I mean, you have some listening skills. You know, that's come on now.
Oh,
You know, the
yes.
other cases and so on and so forth. That's what the impact of the garnishment would be. Ma'am, what can you afford to pay on this judgment on a monthly basis?
I'm gonna, so when I go to court, I gotta go to court and get this off me. This is not my bill. I don't want to pay anything on it.
All right.
I want to go to court and show them my deed that didn't even own the property when that bill was occurred, when DT.
I got it.
I want to go to court so they can just take it off of me. It's not mine. I didn't own the property. I didn't even realize that it was still in my name. And I talked to DT and I even sent them a copy of the deed that I didn't own it.
Got you, ma'am. Okay.
I don't know how much I can pay. Maybe how much, what is it, monthly?
That's okay. You don't have to tell me that because
$25, $50.
You don't have to tell me. You don't have to tell me that because I've talked to you to try and find a way that you wouldn't have to pay that $420 a month while you put together a defense in this case. But you can't tell me what you could pay. And then you said something about $25 a month or something. I don't know how to help you today because a part of this is to try to help you to a solution. So you go ahead and file your paperwork. I'll leave the garnishment in place at this time. I'll find the objections invalid and take place, and perhaps when you ultimately file your paperwork, maybe you can find a way to get it set aside, and then maybe you can get off of the garnishment at that time. But today I gave you the opportunity to tell me something so that I could give you a partial payment plan, so that while you're filing all of these objections and stuff, you can be paying on a partial payment amount of 420 that maybe if you win, you get all your money back. But I can't get you to listen to that, so I'm done with the case, and I wish you well, man. Good day to you.
Thank you, Your Honor.
Yeah, listen, I can hear it now. I'm gonna go on in. Let's go. Let's see what courtroom we're gonna go into. I wonder why when you're in the case,
Because he was telling me.
This is case number 21-685-67. This is Member Select Insurance Company versus Nationwide Insurance. Your appearance regarding this matter for Member Select, please.
Good morning, Your Honor. Heather Thatcher, P83844 on behalf of Member Select.
All right, thank you, Ms. Thatcher, and good morning to you for Nationwide Mutual Insurance. Your appearance at this time.
Good morning, Your Honor. Brandy Koretich, P61505 on behalf of Nationwide.
All right. Are there any other attorneys on this matter?
Yes, Your Honor. James Eccleberry, P 78222, appearing on behalf of plaintiff Ricari Mitchell.
All right. Okay. Got it. I'm looking at my register of action and I don't see. Now I see where the plaintiff is in this matter. All right. Good morning to all. So where are we? Somebody update me on what's going on here.
Yes, Your Honor. This is again Heather Thatcher on behalf of Member Select. We did some digging into Ms. Mitchell's claim and her argument, actually Nationwide's arguments in terms of order of priority. And after some extensive research, we were able to confirm that she was actually the co-owner of the vehicle to which she was assigned on the date of loss. So we are acknowledging that we are highest in order of priority at this time. We're willing to stipulate to dismiss Nationwide with prejudice, and we've asked plaintiff for a demand, which Mr. Eccleberry indicated that he would get to me fairly quickly. So if you just want to push it out at the court's discretion, 30 days, 60 days, I'm confident we'll be able to get this one wrapped up.
All right. Very well, Mr. Eccleberry. It sounds like the right direction to you, sir.
That's correct, Your Honor. I'm in the process of putting together a demand. I need one more medical provider to respond to me, and then we'll have that to counsel and hopefully get this one taken care of.
All right. And Madam Counsel on Nationwide, I know that sounds about right to you.
Yes, it sounds perfect to me.
I remember that issue of the defendant saying that they were on another policy of something being kind of a really thorny issue. So I didn't know that it would get worked out as cleanly as it got worked out. So all right,
Yeah,
so I will sign the appropriate order dismissing Nationwide, and I'll adjourn the matter over for review. I'm going to set that review. Max is going to be like 45 days out, between 30 and 45 days out. And I'll take a look at it on a review in that period.
May 18th.
May 18th is going to be my next action date on this matter. May 18th, and that's going to be at 10 o'clock again. May 18th, 10 o'clock.
Okay. Thank you, Your Honor.
All right, thank you, counsels, and I wish you well as you go forward to the simple part now.
Yes, yes, indeed. Thank you so much. Have a good day.
Thank you, Your Honor.
Thank you.
On this Zoom, other than the case of Jeffrey Cruz versus Cynthia King and Catrice Robinson versus Bobby Harbinson, if there are any other persons on this Zoom other than those two cases that believe that you have something in front of me, say something at this time, other than those two cases. Right, thank you. I'll be right with you all momentarily. All right, the court now calls case number 21-14-5595. This is AZ Electrical Engineering Incorporated versus James Jenkins. The matter is before the court, set on for a hearing on today's date regarding this matter.
Morning, Your Honor. Sam Jarbo, P84564 for the plaintiff in this matter.
All right, thank you, Mr. Jarbo, and good morning to you, Madam Reporter. Are you with you, Mr. Jarbo?
No, Judge.
I'm sorry?
No, I couldn't hear that.
All right, yeah, yes, go right ahead, Mr. Jarbo. Your appearance at this time, sir.
Good morning, Your Honor. Sam Jarbo, P84564 for the plaintiff in this matter.
All right, thank you, Mr. Jarbo. For defendant in this matter, please.
Andrew Patterson on behalf of the defendant.
Thank you, Mr. Patterson. Again, that's Andrew Patterson, P1869 for the defendant in this matter. And that is James Jenkins, is that correct, sir?
Jenkins Construction, James Jenkins. Yes.
Yeah, I didn't have the full spread in front of me, so yeah, I see now the various the company as well as the individual defendant's name in this matter. All right, so talk to me, Mr. Jarbo, for a moment.
Your Honor, we're here for a facilitation. I have my client, this is Wes. Good morning, Your Honor.
Good morning to you, sir.
My name is Wes Jamil. I am co-owner of AZ Electrical Engineering Incorporated.
Thank you, sir. And that last name again is?
Jamil, Jamil.
All right, thank you, Mr. Jamil. All right, and.
Your Honor, Andrew Benson, on behalf of the defendants. And we're here for this facilitation as well.
All right.
Mr. Jenkins had some, I don't know if it was an emergency, but some job site problem this morning. But I think he's back in his office right now. He's just a block away. So.
So you are connected enough
I am connected
with authority to try.
Yeah.
All right, good enough. All right, so has there been any discussions up to this time in terms of trying to get to the bottom of this? I know that this has to do with contractors and subcontractors and some bills that are believed to have been paid, some bills that are not aligned, et cetera, et cetera. So if we can kind of get to the bottom of that, and take a look at it and see if we can kind of move this forward.
Sure. Your Honor, I did send Mr. Jarbo a listing of the bills. We saw them, take construction, what it paid, what it was for. And I think I did myself, but I have not, we haven't had a chance to get back together. Actually, we're hoping today.
Your Honor, at this point, we have an email, and Mr. Jamil has the email. At the finish the job, it's the last email between the parties, where he demands payment for the work that was done. And Ms. Sims, who was a defendant and a party to this lawsuit, states that you will get paid once we get paid. And I'm happy to show you that email. We have it here. It's from Ms. Sims. He can bring his telephone up to you and show you that email. And so I appreciate Andrew, sending me that list and whatnot, but we just blatantly disagree with it based on ample evidence that we have. And so we're asking for around $14,000, Your Honor, and that's where we're at. We feel strong in our case that we can be able to prove that once we get to trial, if we get to trial or if on a motion.
Gotcha. So that particular bill where he received a response, when we get paid, you'll get paid. That's the sum total of what this case is about. That particular bill.
Obviously, another time. Go ahead.
Yeah. Oh, just talking to this, just talking to the plaintiff's side on this. So in other words, let me stop you for a moment. Sure. When he sent out that message regarding that particular billing, was that the 14,000?
That is correct. This case, yes. This is one of the two cases in this Jenkins construction.
A different case in circuit court, Your Honor. It's not on this jurisdiction. It's a totally separate transaction occurrence.
All right. So when you made the contact with someone at Jenkins Construction,
yes, sir.
It was regarding two bills.
Yes, sir. So
well, let me stop you so I can understand the way I need to understand. I was talking about my ears. I was talking about my ears. No,
sorry.
Nothing about your mask. You put your mask back. Okay. Nothing. I was pointing to my ears so that I can understand.
Okay.
What I'm saying is that when you talk to someone from Jenkins Construction, you talk to them about two bills or one bill at that time.
Well, we talked with the controller or the payout account. We talk about one specific contract at a time. So in this specific case today, we have obtained the final electrical permit, electrical inspection for the 500 Griswold, the Guardian building, floor 36. Client moved in, everything's fine. We bill every the 15th of every month. So when we submitted it, this is back on November.
You have two devices, or you have to shut one of them down. Last name Queen, you're up on two devices. That's why that noise occurs. You gotta shut one down. Thank you. I'll be right with you. Go ahead, sir.
I'm sorry. So the final electrical inspection was done on November 27th, 2019. So the following month, which is prior to the 15th of every month, we submit the final billing.
Gotcha.
So since December 15th of 2019 until today, We have not received the balance from Jenkins Construction.
And that balance is that 14,000.
Yes, sir, $15,000, yes. So endless emails are no avail. Jenkins Construction's tactics is
Well,
changing.
I don't want to hear about that. Thank you.
They change controllers, they change.
I heard enough. I heard enough. Thank you.
So just
You still
FYI.
talking? You still talking?
Oh, I'm sorry.
I heard enough.
Okay.
Okay, so, what's wrong with what he's saying? You got,
Nothing's wrong. It's just incomplete. As the court was asking, there were two jobs. And there was a double payment in one of the invoices in the other job. And that's the set off that led to this $14,000 jam. Otherwise, everything.
so you believe that your client is able to demonstrate that they paid double on a particular bill?
I sent a copy of
Let me
all.
stop you for a moment, that they paid double on a particular bill and that double payment is an offset to the $14,000, $15,000.
That is correct. That is the substance of it, yes.
All right. I'm assuming that both sides have something from your accountant or person that manages your inputs and outputs as to what money was dispersed, what money was received. There's not, but here's what I'm getting. There's not a dispute here that there were services performed, which is a good thing. I mean, nobody is disputing, sir, that AZ Electrical performed the service. That's not the issue here. It seems to be that the issue is, and nor are they disputing the amount of the amount that the services are billed for. Nobody's disputing. That's not disputing. What the dispute is that you bill for the services and you bill for services in a second situation. And what they are saying is that they paid you twice for that. What they're saying is that they paid you twice for that second situation and that they should get an offset for the one that you are here today. I don't need to hear about it. We got to work through that. That's just so everybody understands that that's what you want. If you want to say something, you talk to your lawyer about that for a moment. And I understand where the parties' positions are. And let's see if we can work through this in a moment. Now, have there been any exchange of any offers to resolve this?
No, not really, not really. I did send the documentation supporting or set off claim, but I haven't heard back and they haven't had a chance, the parties have to face to face, which is how most of these disputes do get settled.
Respectfully, that was what today was supposed to be.
It was.
Yeah, the parties are together and
I'd still like to do that.
Yeah, no, that makes sense. It makes sense. The issues seem to be a little clearer now. Does the parties have ongoing relationships? I mean, it looks like you have a history of dealing with each other, AZ and Jenkins Construction.
They have, they've worked together before, and I'm assuming you would like to work together again. This is just kind of classic construction.
Yeah, for sure. Brings back some memories, not only from sitting here, but from when I was practicing. The Macomb County issue in particular, and a huge dispute, but that was many years ago. I'm too young, so old. But anyway, so take a minute, the notion of an offset poses a significant potential barrier to trying to get it resolved. That's the notion. That seems to be more of an accounting issue than it is anything else. So oftentimes disputes are resolved by accounting issues, not made more complicated. This seems to be an accounting issue is making it a bit more complicated. Certainly.
Well, that's true, and there's also other issues that make it more complicated. It's our understanding that the plaintiff sued the owner, Wayne County, for the same amount. And I frankly don't know the status of that because surprisingly, the defense hasn't been tendered to us. I have no idea the status of that. I'm just curious myself, what's going on.
So is this claim included in the county loss?
I presume so. Yeah.
I have to go back and look at whether or not there's a county lawsuit. I don't have knowledge of there being a county lawsuit in this matter, but I have to go back and look at that. Are you talking about with the Guardian building?
Right.
That might be a different claim. I have to go back and look at that. I believe that's a totally different matter, but yeah.
He may be right, because I would assume we've been asked to defend, indemnify the owner. It may be, yeah, right.
Might be, I think that's a totally different claim. That might be.
Well, that's good.
Yeah, that's not wrong. Yeah.
One last.
Do you know if this part of the claim is included in your circuit court case? Do you know?
Sure.
No, that's a totally different job.
Gotcha.
But all I know, sir, there's two lawsuits against Jenkins.
Yeah.
One for the 8th precinct, and one for the Guardian bill.
One for the guardian. This is the guardian bill.
Yes,
Yes,
correct.
sir. Yes. That's all I know.
Perhaps we can have another conference by Zoom this time, so we don't have any complications as to whether or not people come and we can actually have clients here. You know, maybe that'll bridge the gap and by then we can look at the accounting and hopefully come to hey, I'll call Drew and say, you know what, you were right, or he'll call me and say you were right, and we can resolve it.
I was hoping we could do that today.
Yeah.
Sorry.
Yeah.
Maybe, could we adjourn to Jenkins' offices down the street? And come back there and let you know?
Yeah, I mean, listen, I want to do as much as I can to facilitate this, and I see that we've been able to narrow the issues, even though the parties are in a different position. That's, I know you have your clients in here. When the issues are being narrowed, that doesn't mean that the court has found one side or the other side. It just means that it's clear before the court as to what the dispute is. That's where we are right now, as to what the dispute is. The next question is how do you bridge the difference, and is there a reasonable chance that you can bridge the differences here? If you want to go over to the Jenkins office and see if you can hammer this out, the court is exercising control over everything. If there is if you're able to work it out, if you need more involvement from the court, then all you got to do is jump on Zoom from there, and I will engage with the parties involved. Today, I'll stay up and engage with the parties to try and get this to some kind of conclusion today. If you can't do that, it will set another time. So somebody will need to zoom in with me. I have to be on over there and see where we are, and then we'll make a decision about what happens next.
Thank you.
Your Honor, I'm not sure if we can make it to the office today. Are you able to go today, Wes? I know I have a 12 o'clock.
Okay, listen, I'm willing to resolve this and then by all circumstances. But the attorney here is quite, may I say something just for the record?
Go ahead.
Thank you, I appreciate it, Your Honor.
You got 15 seconds.
You got it. What he's saying is totally untrue. Jenkins Construction, they pinch their money. So one overlapping the other is totally irrelevant. So the notion that they
Let me stop you
overpaid
now.
us.
Let me stop you now. You may be right.
Thank you. Yes, thank you.
You might be wrong.
Yes, sir.
That's
Thank you.
that's what we trying to work out here. Okay.
They acknowledged it.
Let me put it this way.
Yes, sir.
If the records show that money was sent to you that was aimed at various accounts, and that in doing that, in the accounting process, that you got overpaid on an account that they wish to apply for this particular account, it would make sense that they get a credit for that, correct?
Correct.
On the other hand, if the records show that they're mistaken about that and that they owe you money, it makes sense that you get paid the money that they owe you, right?
100%.
That's what the case is. That's what it is now. And we gotta find out, some of that can be found out by the accounting process. Some of it may not be. And the part that can't be, then that's when we start trying to bridge this gap. Because the ideal here is that if you're owed some money, in this case, then you should get the recovery that is due to you. There's no question about it. And Jenkins Construction does not appear to be taking the position that if we owe you money, we don't want to pay you. That doesn't seem to be the position that they're taking. They're taking the position that we think we paid you, and so if we pay you again, we're overpaying you. They could be wrong. They could be dead wrong, but we need to find that out. That's what I'm doing. Yes, sir.
I suggest a proposal, and obviously at the discretion of your honor. We submit counter briefs for your review, and then maybe you can issue an opinion on those counter briefs. Maybe give us 2 or 3 weeks until then.
I'm willing to do it that way, but you're making me an accountant.
Yeah,
And,
I'm inclined to say the party to face-to-face, do whatever. We don't need to do it necessarily today. face-to-face regardless.
Here's what I do. I'll set up for you guys to mutually come together face to face over the next week. And 2 weeks from now, set a time for you to come back, because I know this has been going on, so we're trying to get to the finish line here. So I'll set it up for you to come back in front of me 2 weeks from now. You can do it by Zoom. If you stipulate you want to come in person, then you can do it that way. Otherwise, it'll be by Zoom. But if you say, well, I think it's, if the two of you say we want to come, then just let somebody in the building know, my clerk or somebody know, and I'll make sure that you're able to come in and be here in person. Otherwise,
That works for me. You're gonna set that time, you'll send us notice?
yeah, I'm gonna give you the date now.
Okay, great.
Just a couple of weeks out, my clerk, so you do that. Just a moment. So 2 weeks down, or just past 2 weeks, or another date. For you on this.
25th.
25th of April.
Monday, the 25th.
Oh, you know what?
It worked for me.
What time?
27th.
Just one moment. The
I won't be here.
27th works better for us. Wednesday, the 27th, and we'll set that at 10 o'clock a.m.
10 a.m. That's good.
All right. So between now and the next now and the next 10 days, I'll give you a 10-day period. On or before the 16th, you are to get together and have a meeting in person in good faith to look at the particulars. And then you have a control date in front of me on the 27th, and I'll take a look at whatever particulars you want to present to me at that time. We'll see if we can get this to the finish line.
Thank you.
Thank you. All right. Wish you well, gentlemen. Thank you for coming in.
Oh, I post the meeting at the office.
Excuse me.
This is case number 21-241-240. This is Catrice Robinson versus Bobby's Towing. The matter is before the court on an appeal from a determination by a magistrate in this matter. And that appeal is an appeal of right, and the court hears the matter in novo. All right. I have Catrice Robinson on this matter. Is that correct?
Yes.
All right, thank you, Ms. Robinson. And also, I have someone, I believe, from Bobby's Towing. Who is that again?
Denise Boyce Hardison.
What's the last name again?
It's hyphenated Boyce, BOYCE hyphen HARDISO.
You broke up just a little bit. Okay, give it to me again. Your last name is?
Boyce. Can you hear me?
Boyce?
Boyce with a B, BOYCE.
Gotcha. And you said
Hyphen Hardison. HARDI.
Gotcha. All right, thank you, ma'am. All right. So let me have the two of you raise your right hand. You have any other witnesses that might testify regarding this matter?
Yes, I do. Let me call him in.
All right.
All right, he's here, sir.
All right, thank you. What's your name, sir?
Desmond Jackson.
Thank you, Mr. Jackson. Desmond Jackson, you said, correct, sir?
Yes.
All right, let me have the three of you raise your right hand to be sworn at this time. Also, thank you. You do solemnly swear affirm that the testimony that you're about to give regarding the case that is before the court will be the truth and nothing but the truth, so help you God?
Yes.
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 All right, thank you very much. Inasmuch as this is the plaintiff's claim that is brought before the court, and it was appealed to this court, the plaintiff gets the opportunity to go forward first and to tell me what this case is about. And the testimony you offer is testimony that's being offered in the oath. There are no interruptions. Once the plaintiff has finished with the offering of her case in this matter, the defendant will have the opportunity to present her side of the case as well. I will give opportunities to ask questions of the other side if I find that to be an appropriate thing to do. At this time, everyone else will be silent, and Ms. Robinson, go ahead and tell me what this case is about.
Thank you. So on September 24th of 2021, yes, I was falsely accused and convicted of a felonious assault with a motorcycle. So the police department came. I was also acquitted of those charges as well. The police department.
I do have to stop you for a moment because you told me you were falsely accused and convicted, but now you tell me you were acquitted of those charges. Were you convicted or acquitted?
I was acquitted.
Okay, you were found not guilty or something along those lines, correct?
Yes.
Okay, now you know you said earlier that you were convicted. I mean, that's convicted is the opposite of acquitted. I think you were saying you were falsely accused and charged with a crime, correct?
Yes, that's what I was trying to say. Thank you.
You were not convicted of a crime, right?
No, I was not convicted. I was accused of a crime.
Okay, gotcha. All right. So go ahead and finish telling me what happened. So you were acquitted of the crime that they accused you of, felonious assault involving a motorcycle, and something happened as it relates to yourself and the plaintiff, the defendant in this matter. Go ahead now.
Yes. So the Bobby's Towing Company was called to my residence to tow the motorcycle, and in the process of them making the tow, they damaged the motorcycle. I have a estimate because the motorcycle was just I don't know if I want to use the word refurbished, but it was just out the shop from a accident. So I have all the receipts and everything here that I just had those things done to the motorcycle. So when they were towing the motorcycle, there is police dash cam. They kept trying to jam the dolly, so to speak, I guess that's what it's called, underneath the tire to hook up the dolly to pull the bike up onto the tow truck. And they made several attempts. However, they failed. And during that course of them making those attempts, the kickstand was damaged, the fender was damaged, the crash bars were damaged, and a couple other things. I have a list of the items from the motorcycle place.
All right.
Yes. So I informed the tow company. I also have video of when I went to pick up the motorcycle of the damages that had occurred. And I was awarded the damages.
Stop. let me stop you there. You can't tell me what damages you were awarded by a magistrate because the court considers this de novo. I'm looking at it new and fresh. Okay, let me ask you a couple of questions as you go forward to talk to me about this. You indicated damage to kickstand, fender, and crash bar. What was the condition of your motorcycle at the time that the tow truck company began to move it at the instruction, I suppose, of the police? Go ahead.
It was in excellent condition.
So had it been in an accident that day, when it was instructions to tow it?
I'm sorry, was it in an accident that day?
Yes, ma'am.
No, the accident actually occurred a year before.
All right.
So
Okay, so it was subsequent to the accident that the instruction was to tow your vehicle, and that towing was from your home, was it?
Yes.
Okay. And you're saying that you had recently had the vehicle refurbished and that there was no damage to the vehicle at the time that the towing process began. Is that correct?
That is correct.
And after the vehicle, was the vehicle actually towed? You said something was unsuccessful.
Yes, they were, the vehicle eventually was towed. They came the first time because the police had to make the report for the tow truck to come out. So when they came out the first time, they had to leave because they didn't have the appropriate tie downs. So they came back the second time, and in the attempt of trying to load the motorcycle onto the truck, they had several difficulties trying to load it. So they almost dropped it a couple times. You can see it. It was it almost went down on the side from them tying it down with the tie downs. They tied it so tight on the crash bars with the kickstand down that it bent the kickstand, and the crash bars are bent in the opposite direction. So the crash bars are supposed to just, be this way, but they're pulled forward towards the front from them trying to tie it down. And then the front fender is bent underneath on each side from them kept trying to jam that dolly. I'm not sure if it's called the dolly, but whatever they use to put underneath the front tire to hook up the cable wire to pull the bike up on the bed of the tow truck. So that
All right. So let me ask you, so how did you determine, or how did you assess what the nature of the damage was or is to the motorcycle, man? Tell me what you did.
I had to take the motorcycle to the motorcycle dealer.
Right. And as a result of doing that, you found out some information in terms of what repairs were needed?
Yes.
All right. Tell me about that.
You want to tell you what repairs were needed?
Needed and or done. What happened? Tell me about
Yes.
that.
I had. Do you want me to put the receipt up to the camera?
At some point, I want you to, but the first thing I want you to do is tell me what you went there for and so on and so forth.
Yeah. So when I went. So when I went, of course, I told them the situation because I just got the bike from them probably a week. And I told them that I needed an estimate because the tow company had damaged the bike in the process of them trying to tow it. So they looked the bike over and that's when they discovered, because the kickstand was just brand new. I had to have the kickstand installed. So they discovered that the kickstand was slightly bent, and that the spring in the kickstand was messed up. The weld of the highway bar and the lower fairing crash bar was bent. The trim tip of the front fender and the trim of the front fender and the fender assembly needed all to be repaired.
And was that the only company that you went to have them review what the damages were to your bike?
Yeah, it's an Indian motorcycle, so I could only go to Indian dealership.
All right, what type of motorcycle? You said Indian?
Yes, Indian, not Harley, Indian.
Indian, spell that for me. If you
Indian, Indian.
Okay, now I've heard of Ducatis and everything. I guess I don't know enough about motorcycles, but it's called Indian. Okay.
Well,
Got it.
Indian was the first motorcycles before Harley and any other.
Well, they need to catch up then. Anyway. Okay, so what was the estimate in terms of the cost of repair or corrections on the bike?
The estimate came to a total with labor included was $2,407.27.
$2,407.27. Any of the repairs that are associated with that particular amount, are any of those repairs, anything that was wrong with the bike already, or something that you would have had to take care of outside of whatever occurred when the vehicle was towed?
I'm sorry, can you rephrase the question?
In other words, I'm asking you to separate out from that deal any damages that may have existed on the bike that are not associated with this incident. In other words, are they fixing anything that wasn't associated with this incident?
No.
Did you in fact get the bike repaired?
No, because we're out of bike season.
Okay, all right, but you didn't get it repaired because it's not the season for repair, or because you didn't have the money? Anyway, you don't have to answer that question, but okay, it wasn't the season for it. Got it. All right, so you did you file any or did you do any did you file any complaint with the complainant with the defendant Bobby's towing? Did you let them know about anything that was going on with the motorcycle?
I did, and I also filled out a report.
When you say you filled out a report with whom?
With Bobby Sewing.
Okay, and that was at the time that you picked up your vehicle? Is that when you did that?
What? I'm sorry, can you say that again?
You filed your report at the time you picked up the vehicle? Is that when you did that?
Yes.
Okay, so how long did Bobby's Towing have the vehicle before you picked it up?
I was incarcerated over the weekend. So I think I went on Tuesday. I could look at the receipt.
All right. Were you responsible for any towing fees or storage fees or anything at the time?
I was. I had to pay the fee to get it out of the impound.
All right, and you did in fact take care of that. Is that correct, ma'am?
I did. I'm sorry. I did pay for it to get it out of impound.
Do you know how much you paid?
Just one moment. Yeah. I paid one fee. I paid $75. I believe that's the towing administration fee.
All right.
And I paid another one. I would have to pull up the picture for the other receipt.
All right, so do you know approximately how much the other one was? How much you paid in total is what I'm kind of getting at.
Yes, I think it's like $25 a day for a motorcycle. So it was in there Friday, Saturday, Sunday, and Monday, and I picked it up on Tuesday morning.
So maybe an additional $100 or so, correct? That's what you're saying?
Yes, yes.
So when you picked up the vehicle, ma'am, how did you pick it up? Were you able to drive it away? What were you able to do with the vehicle when you picked it up?
Yes, I was able to drive it away.
Did you notice any damage at the time that you picked it up?
I took a video. I was not able to visibly notice the damages right away. And then once I got the vehicle home, I took another vehicle, but I have a vehicle of it on the lot on their property of the damages. And then I have another vehicle, another video when I got the bike home. And then I took the bike a couple days later to the Indian dealership.
All right, gotcha, man. Anything else you want to tell me at this time, man?
I'm just, yes. So I just want to know why am I even here when they appealed for the case past the 7 days for the appeal?
Well, I don't know anything about that. I know it was set up in front of me, so that would give an indication that they were timely in their appeal, otherwise it would not come to me. The answer to your question is somehow the appeal was allowed and it was presented to me. All right, so all right, anything else?
I just want to get my money to repair my motorcycle. It's almost riding season again, and I want to get it in the shop and get it repaired.
I thought you weren't repairing it because it wasn't the season, but oh, I see now.
Right, it's the season now. This happened last year, and I need to get it in so they can order the parts. It takes a long time for these parts to come in.
Gotcha. All right, let me hear from the other side on this and see what their perspective is in this regard. All right, so I know that there are two persons that want to say something about this matter, and they can't, of course, talk at the same time. So who is going to go first in this regard?
I am. Artisan.
All right. Thank you, Miss. Thank you, Miss Boyce Hardison. And let me ask you: are there any questions that you want to ask of Miss Robinson? Any questions that come to mind that you might want to ask of her?
The only question I would like to ask her is when she went back the bike before she paid to have the bike released, why didn't she mention the damages at that time? She left with the bike. She paid for the bike, left, went home, and came back the next day and filed a complaint. The damages that she's saying that was.
Let me stop. Okay, her question, the question that Miss Hardison has for you is, why didn't you file something at the time that you picked up the bike? She acknowledges that you came back the next day, but she wants to know why you didn't say something at the time you picked up the bike, Mrs. Robinson.
Because I don't know if it's her grandson or her nephew was the one that helped me. And I specifically asked him if there was any damages, because I don't know how the procedure goes. I've never had a vehicle impounded. I specifically asked if there was any damage, what do you do? And he specifically said to come back and file a report. And I have that report paper on my phone. Because
okay, let me stop you. I think you answered the question, and it is acknowledged that you did file a complaint. Ms. Hardison, before you get a chance to talk to me about what you want to talk to me about, any other questions that you want to ask? I'm going to give you a chance to tell me what you want to tell me. Before that, if you have another question or anything, go ahead.
No, there's no more questions for her.
All right, thank you. Thank you, Ms. Hardison. You may proceed at this time. Tell me what you wish to tell me regarding this matter.
Okay, so the Detroit Police Department did call us out on September the 24th to have the motorcycle towed. At the time, I had 2 drivers to go out to tow the motorcycle. I'm not going to say that they didn't have a hard time putting the vehicle on the motorcycle carrier, but the video that she showed, the magistrate showed them trying to load the vehicle from behind, which would, I'm assuming, make her think that they were smashing the tire or the fender up against the motorcycle carrier. I did send you guys a video showing a motorcycle being loaded onto the motorcycle carrier, which would give you the view of the tire and the fender, showing that you can't do any damage. It is a little rough to take that the motorcycle on top of the carrier and seeing that her bike is like a bigger bike and it's a little heavier. So it wasn't like a straight shot, but what it showed in her video was not that it was doing damage. It really only showed that they had a hard time loading the bike on there. The bike never fell in the video at all, which she stated that this morning. It never fell. They never lost control of the bike. They just had a hard time pushing the bike up on the dolly. She did come out and look at her bike. She accessed the bike prior to her taking the bike or even paying for the bike. When she came back in, if there was a problem with the bike, she could have filled out a damage complaint at that time and given us an opportunity to go out and take pictures to see what the damage of the vehicle was. We don't know what happened to the bike when the bike left here. She did come back the next day and stated that the bike was damaged, but again, I'm not sure what happened to the bike after it left. And from my knowledge, she did try to run someone over with the bike. And and I know I can't say what somebody else said, but I won't even tell you that part because I know I can't say that. But we did not do any damage to her bike at all. The pictures that she have here, which I have the pictures also, was showing she took pictures of the bike inside the lot. She took a picture with the bike sitting outside in front of the lot. She had all the opportunity to come back in and tell us that the bike had been damaged at the time she picked up the bike, so we could have assessed it to see if in the event that we did do some damage to the bike. Bobby's Towing did not do any damage to the bike. And even the pictures that she showed does not show any damage to any bike. And the impound card states also, before the drivers picked up the bike, that the bike was in poor condition, and that came from the officers who impounded the bike.
All right, let me ask you a couple questions, ma'am. With regard to the impound notations regarding the bike being in poor condition, did they say anything or did they put anything on the impound other than that in terms of describing what they meant by poor condition?
They did. It says rate condition from 1 to 5. 1 being excellent, 5 being poor, and they put 5 for the condition and 5 for the interior condition. I'm sorry, 5 for the exterior condition and 5 for the interior condition.
And you're saying that even though they gave that notation, they did not describe what they were talking about as in poor condition, correct?
No, they didn't.
Also, let me ask you, once your agency received notification the day after the vehicle was picked up regarding the claim of damages, has your agency sent someone out or requested the vehicle for purposes of inspection since that time?
No, we have not.
All right, so, okay. Anything else you want to tell me at this time?
No, sir.
Ms. Robinson, any questions that you want to ask Ms. Hardison at this time?
I'm not sure if it's a question, but I just wanted to go back and reflect on a couple of things.
Let me stop you for a moment. Right now, it's only if you have a question. You're the plaintiff. You're going to get the last word in this case. So right now, I only want to know if you wanted to ask.
Okay, then I don't have a question. I just have some statements.
All right, very well, ma'am. All right, I know that there is a witness that you have also, Ms. Hardison, and let me have that gentleman to come forward if he wishes to testify at this time. And I know you gave me your name earlier, sir, but give it to me again, if you will.
Desmond Jackson.
All right. I don't know how I forgot Desmond Jackson. That's about as straightforward as you can get. All right. So, Mr. Jackson, you work for the Bobby's Towing, is that correct, sir?
Yeah.
And you were working for Bobby's Towing in September of 2021, is that true?
Yes.
All right. It seems to me that while this case is about a claim that that a certain motorcycle was towed and that ultimately there was some damage to that vehicle. That claim is made by Ms. Robinson. You know anything about that particular motorcycle, sir?
I'm sorry, Judge, if I could just verify, you said it in September of 2022, this was September of 2021.
I thought I said 2021.
Okay, I may have misunderstood you. I just wanted to have the date.
I couldn't possibly be wrong. If I said 22, I certainly meant 21. All right.
Okay.
Mr. Jackson, were you involved in towing Miss Robinson's vehicle?
Yes.
All right. Tell me what you wish to tell me about that matter, sir.
We arrived on the location and we had to get the proper carrier for the bike. The bike was heavy. We were trying to get the bike to push up onto, get the front wheel to lock into the motorcycle carrier. We had some problems trying to get it up there. We held on to the bike. We were able to finally get the bike pulled up on the tow truck and tie it down. There was a time where the bike did lean in both directions. And all I remember is holding that bike and not letting that bike fall, or barely no touching on the ground. I let the weight of the bike lean up against my body until my partner was able to help balance it.
So there were two occasions when Bobby Storm was out there. Apparently, the first time they didn't have the right equipment, and then the second time they came with the equipment that would be needed. Is that the size of it, or was this all one occasion?
Yeah, this was I didn't know it was a motorcycle when we arrived on the location.
So somebody, when they first arrived there, there was an attempt to move the bike, but you didn't have the right equipment. Is that what it was?
That's correct.
Okay.
We need the motorcycle carrier.
And so there was the motorcycle carrier or whatever the equipment that was being used. There's some device or some something that pulls the bike forward.
Yeah, the device that you lock the front wheel of the bike in, and then that allows you to strap the bike to the carrier, and then you put the hook to the bike carrier and pull it up onto the flatbed.
And once pulled on the flatbed, does the bike lay down on the flatbed, or does it sit up on the flatbed?
It sits up.
All right. Anything further you want to tell me at this time?
No, I don't have any further questions.
All right. There was something that was indicated to me by Ms. Hardison. She indicated that the conditioning of the vehicle, there was a note card or something that indicated a condition as 5 regarding interior and exterior of the motorcycle. You know anything about that, sir?
I would not have known any of that information being a driver.
All right, so it was you and another person that was working at getting this up onto the bed. Is that correct?
That's correct.
Thank you, sir. All right. Any questions, Ms. Robinson, that you have for Mr. Jackson? Any questions for Mr. Jackson at this time?
For the tow guy?
Yes.
Yes. I wanted to know when the object is the object called a chalk for the front tire to fit into that thing we call a dolly, where they pull the bike up, because they kept trying to put that underneath, and because the fender of the motorcycle is a wraparound fender, which means it goes from the very front of the tire.
Let me stop you teaching motorcycle now. Your question seems to be what is that device called that you lock the front tire into? That's your question?
Yes.
All right. If you know, sir, what is that device called?
Motorcycle carrier.
Oh, carrier, motorcycle carrier.
Gotcha. Any other questions?
Yes, when he came with another driver or coworker. Did you and your partner first try to load the bike with the kickstand up or down?
We have to put the kickstand up in order to get the bike from off the ground from freestand.
So did that happen?
Yes, it did.
When did that happen? Did you do that on your own, or did someone have to tell you to pick the kickstand up?
Well, my trainer, my coworker is experienced with towing motorcycles. So it was no doubt he knew exactly how to move the bike in order to properly load it.
So is it fair to say that you do not have knowledge of how to load or tow a motorcycle from standing?
Yes, I have motorcycle towing knowledge and experience.
So was the kickstand up or down? And did someone have to tell you to put the kickstand up or down?
The kicks.
I believe it. You testified.
Touch the.
Stop for a moment.
Hold it.
Let me stop you for a moment.
I'm sorry, Judge, I'm sorry, excuse me. What, I can't hear you. I'm sorry, you're going in and out when you're talking.
That's why I'm stopping everybody. I may have muted you, and if I muted you, you can unmute yourself in a moment. I hope that everybody can hear me. I was saying that question is a compound question, and it seems to me that Mr. Jackson already answered that the kickstand was up. Mr. Jackson, also, I believe that you said that the person that was with you, or you insinuated the person that was with you was more experienced with loading bikes than you were. Is that correct, sir?
Yes.
All right, but you also said that you knew something about loading bikes, just that person was more experienced, correct?
Yeah, that person is the person who was responsible for teaching me how to properly load
Gotcha.
motorcycle.
All right. Thank you, sir. All right, Ms. Robinson, you will have to hit *6 to unmute yourself so I can hear you now.
I'm here.
All right, got you. All right, any other questions that you wish to ask at this time, ma'am?
Yes, he stated that the other guy is more experienced. I want to know, why isn't he there? Because I have specific detailed video from the police dash cam of them loading my bike.
That doesn't sound like a question though, does it? It really does.
Well, the question was, I wanted to know why the more experienced loader is not there and he's there.
Because he doesn't have to be here. That's just the witness that they chose to be here. Okay.
Okay.
Anything else?
No, I'll come back. I don't think I have a question right now.
All right, thank you. Anything else you wanted to say at this time, Mr. Jackson?
No.
All right, very well. All right, Miss Robinson, go ahead and tell me what you wish to tell me at this time, ma'am.
Yes. So at the time of the towing, is clearly seen in the police dash cam that they were careless and reckless in towing the motorcycle. The motorcycle did go over 2 or 3 times, if not 4, and that the kickstand was down when they tried to move, because in the video, you can hear me telling them to pick the kickstand up. And that's why the kickstand is damaged. And then when they finally loaded the bike, they used those tie downs in the wrong area, which caused the crash bars to be pulled forward because the tie down, they tied it so tight. The other thing I have is the video of the other tow guy specifically saying that they had a very hard time towing this bike. And I specifically pointed out at the tow yard where the damages were.
All right, now you pointed out, you testified earlier that you didn't point out any damages until the next day that you filed your complaint. Are you saying now that on the day that you picked it up, you pointed out some areas of damage?
No, the tow guy was not there.
Okay, when did you said that you pointed out the areas where there was damage. When did you do that?
I think when I went back to make the report.
Did you have the bike with you at that time?
I did.
All right, and so to whom did you make the report, if you recall?
I'm sorry, when?
No, when you went back the next day with the bike, who did you make the report to? Who did you deal with?
This young lady, I'm sorry, I don't know her name.
You're talking about Miss Harbison that's on the Zoom?
Yes.
All right, you dealt with her, and so you pointed out whatever the problems were to her the next day, correct?
I did. I actually called the same day and explained to a gentleman that answered the phone and told him, and he said the same thing, come back and make the report, and that's what I did.
All right. And when you made the report, Ms. Hardison was there, is that correct?
Yes.
Okay. There was an indication, let me stop you for a moment. There was indication that there was, when the vehicle was towed on the towing report, they indicated that there was this vehicle was given a 5 indicating poor condition externally as well as a poor condition internally. What when you think about your vehicle, do you have any idea why there would have been a 5 given indicating that the condition was poor? Go ahead, Matt.
Yes, and I have that too. The reason why is I can only speculate because they thought that 1 meant poor and 5 meant the greatest. They had it switched around. And then
Let me ask you,
I don't know if
let me stop you for a moment. How old is the vehicle? What year is it?
17, 2017.
17. Did
Yes.
you buy it?
Brand new.
All right. Okay, you had something else to say. Go ahead now.
Yeah, so when I went back to and got the report, she gave me the report to fill out. And then I guess she realized who I was. And after I signed the report, then she puts on there that she's not going to pay for the damages. I have two pictures of when I signed before and after I signed the report. So after I signed it, then she puts on there that she was not gonna accept responsibility.
All right, not a problem. All right, thank you, ma'am. I'll come to one moment.
Your Honor, I do have one question if I'm allowed.
Yeah, I was coming to you. Go right ahead, Ms. Hart.
Okay, yeah, I just wanted to ask Ms. Robinson, if she witnessed them damaging the vehicle, the motorcycle when they towed it, that should have been the first thing she came into the office and stated. And again, she went back and looked at the bike. Before she left, she said she knew all of this damage was done. What was the reason for her going home and coming back the next day? And yes, I did allow her to fill out an incident report. I did not know what vehicle, what it was in regards to. until after she filled it out, and I looked it up to see that the bike was released the day before. And that's when I wrote on there that we was not going to take responsibility because she should have showed us or informed us of the damages when she picked up the bike.
All right, thank you, ma'am. All right, I don't know if that was a question or whatever. You guys have to learn what questions are. But I think in all that statement, there was an inquiry as to why you didn't say anything about the vehicle at the time that you picked it up, Ms. Robbins.
Yes, because again, as I've stated, I'm not an expert. I've never had an accident on a motorcycle. So in order to understand what the damages were, because again, I don't, you have to really be professional in determining where the damages occurred. And my only thing was, I was concerned about the kickstand more than anything else because they kept trying to move the bike on the kickstand. So when I went to retrieve the bike, I noticed that I think the crash bars, I can't say. Because I got the bike home. I have a video of both. When I got the bike home, and I have a video of when the bike was in the impound and the damages are they're visible there on the video. And then I have a video when I got home and noticed some other damage. That's why I called for the second time. Well, I can't say I called. That was the first time that I called. I spoke to them while I was there. And then I called when I got home. So that was the second time that I had talked to them and informed them of the damages. And I had to go back and fill out the report.
All right. All right. I think I've heard enough regarding this case. And I want to thank you all for your input and your involvement in this matter. All right. I listened to the testimony that's been offered by the three persons who testified. And
If I may, I have a question.
What's your question, ma'am?
I'm sorry. Is there a law for no fault that a motorcycle is not considered a vehicle if it does not have 3 or more wheels?
Well, that's not a question that has any relevance to this particular case. And so you have to go research that yourself.
Well, I'm asking because she sent it to me.
Well, you all can talk about all that, whatever you want to. That don't have anything to do with this case.
Well, that's why she said she didn't want to pay.
Well, I don't care what she said about not wanting to pay or anything. I don't care anything about that. I'm the one making this case. That don't have anything to do with anything. This
okay, thank you.
No, don't try to cut me off now. This doesn't have anything. This doesn't have anything to do with that. This has to do with a claim that a piece of property was damaged by another. This
thank you.
Have ownership and operation of a motor vehicle under the no fault statute or any other statute. This is it could be the dollhouse that got broken, whatever. The question here has to do with whether or not a piece of property that was in possession of another was damaged by that other person, such that the plaintiff should be granted relief. That's what this case is about, as it sits in front of you. All right, I've listened to the testimony offered in this matter, and in this case, it is the duty of the plaintiff in this matter bringing the cause of action to establish by a preponderance of the evidence that the proposition she offers before the court is true. And that is that the plaintiff has to preponderate. That means she has to show enough evidence that establishes that there is evidence that tilts the scale in favor of the proposition that she brings before the court. In listening to the evidence offered in this matter, this is a situation that Bobby's Towing is brought into by virtue of a request from the apparently the Detroit Police Department that directs them to go to a certain location in September of 2021 for the purposes of towing a vehicle, a motor vehicle, a motorcycle for as a part of a charge and or investigation by the Detroit Police Department. Bobby's Towing has the duty under law to engage in the practice of their business in such a manner as to be done in a reasonable way, such that any operation of their business does not cause damage or injury to property that may be in their possession or may be under their control. It is without any reasonable argument that there were 2 instances upon which the defendant attempted to place the vehicle on a proper flatbed for purposes of towing it away. It is without question that the parties, I should say that Bobby's Towing had the intent of exercising the utmost care in trying to get the vehicle up on the flatbed. The reality of it is that they had difficulty doing so, and significant difficulty doing so. Part of that difficulty was verified by testimony of Mr. Jackson, who says that there were occasions on which that he held the bike up by his own body, such as to not let the bike fall down and become damaged in any significant kind of way. There is without dispute that there was a struggle getting the bike onto the flatbed. Ultimately, it was transferred to the proper towing yard. It was kept for a few days because the plaintiff testified that she was not available. She was locked up. And when she got out, she went and retrieved the vehicle. Upon retrieving the vehicle, she says she noticed that there was some issues with the kickstand that she believed would be a problem because of how it was towed. And the next day, she brought the vehicle back and pointed out various conditions on the vehicle and filed a report with Bobby's Towing. Subsequent to that time, she went to a repair agency to seek repair for conditions that existed on the property. They found out that there was some damage to kickstand, to fender, to crash bars, and that the cost of repairing those conditions are in the nature of $2,400 to correct those conditions that existed on the bike. From the testimony that I've heard, particularly where there was a struggle with regard to this vehicle. Secondly, where Miss Robinson picked the vehicle up from the tow yard and left with the vehicle, and then later comes back a day later indicating that there are problems. All of these suggest that there was not an effort to make up conditions as it relates to the vehicle. Elsewise, the defendant would have, the plaintiff, Ms. Robinson, would have showed up and would have began to make up things concerning the condition of the vehicle. She got it out of the tow yard. She inspected it. She called back to the tow yard the same day and then actually brought the vehicle back up to the tow yard the subsequent day to point out what the damages were with regard to that vehicle. Also, that was an effort to remediate damages, to give the defendant an opportunity to bring corrections where there had been damage to the vehicle. The parties not being able to resolve their issues at that time, and that's understandable. Perhaps further investigation was in order. The fact of the matter is that the vehicle was in fact damaged. There is a sufficient evidence to ponder it, to establish that the claim that is brought by Ms. Robinson if there is enough evidence to show that she tilts the scale, that her vehicle that did not have damage before the vehicle was towed has damage after the vehicle is towed. And the type of damage that is described is damage that is consistent with the struggle that was had in placing the vehicle onto the bed. Now, if this was a situation where Ms. Robinson brought in a claim saying that the frame was cracked on the vehicle, that the vehicle handles were broken such that there would be evidence that the vehicle fell off the truck, the evidence that the vehicle was dropped, then that would be inconsistent with the other information that's provided in this case. The claim that is brought is not a claim that the vehicle was dropped. It's not a claim that the vehicle fell off the truck. It's not a claim that the vehicle is totaled in any way. It's a claim that there are nicks and bends and other kind of damage that occurred in the process of the towing of the vehicle. It's an unfortunate kind of situation, but it sounds to me that when Bobby's Towing came out to tow this motorcycle, that they weren't quite sure exactly what to do, and they tried a number of things. Ultimately, they figured out exactly what they should do to get the vehicle up on the flatbed. That's what the testimony suggests, and particularly from Mr. Jackson. And they ultimately got it up on the bed. Not only from Mr. Jackson, but also the testimony from Ms. Robinson on her observations, and that mistakes were made. Those mistakes resulted in damage to the vehicle, and that damage to the vehicle has been summarized by a report issued by the repair shop that indicates that it's going to take $2,407.27 to correct the damage that occurred. My finding then is where the plaintiff has carried her burden of proof in this matter, that the plaintiff is entitled to judgment on the complaint offered in this matter, and that judgment will be an amount of $2,407.27 plus the court costs that is relevant in this matter. I will issue a judgment consistent therewith. That is my order. All parties will receive a copy of the order in the mail from me shortly. Good day to you.
All right, thank you.
Just one moment, Mr. Cruz and defendant on the other matter. I'll get to you in just a moment.
Okay, you have to take your time.
Can you tell me how long she has to pay, Judge?
Ma'am, I don't have time to calculate it down. It's going to be 24 or something plus.
No, I was just asking. I'm sorry. I was just asking for the days, how many days she has to pay.
Well, she has 21 days to pay the judgment. If she doesn't pay it after 21 days, then you have the right to engage in collection proceedings.
Okay, thank you. You have a nice day.
Likewise to you. All right, this is case number 21-240735. This is Jeffrey Cruz versus Cynthia King. The matter is before the court on a claim of appeal from the division of this court, the small claims division of this court. For the plaintiff in this matter, Jeffrey Cruz, Clean Cut Management. Your name for the record, sir.
Hey, good lunchtime, Judge Coleman. Jeffrey Cruz, doing business at Clean Cut Management Company.
Good morning, Your Honor.
Let me look now to Cynthia King, living on Sutherland. If you're on the Zoom, please say something at this time.
I just said, good morning, Your Honor. This is Cynthia King.
All right, thank you, Ms. King. Let me put your name in there so I can exactly where you are. Just one moment. All right, the court does hear this matter. They know what I'm looking at now because it looks like all right, it looks like Ms. King appealed from whatever decision was made in the small claims division of this court. All right, let me have Ms. King, are you able to come on the screen so that I can get you sworn for purposes of testimony here, ma'am?
No, Your Honor, because I was trying to come on the screen and it wouldn't come up. I've been having trouble with trying to get Zoom up on my television. I guess I don't know what's going on with it. I don't know if it's the circulation in my house or what, but that's why I went on the phone because I couldn't get it to come up.
All right, gotcha. I need you right where you are right now. Raise your right hand and be sworn. Mr. Cruz, if you would do the same. You do solemnly swear or affirm that the testimony you're about to give regarding the matter before the court will be the truth and nothing but the truth, so help you God. Is that correct?
Yes, I do.
Mr. Cruz?
That's correct. I do have a witness, Your Honor.
All right, and is that Annette Cruz that I'm seeing there as well?
Correct, Your Honor.
Ms. Cruz, if you raise your right hand and be sworn at this time, you just solemnly swear or affirm that you will tell the truth, the whole truth, and nothing but the truth regarding the matter before the court, ma'am?
Yes, Your Honor.
All right, thank you, Ms. Cruz. All right, Mr. Cruz, this is a claim that you brought before the court. So let me have you go first and tell me what this case is about, sir.
Okay, well, this is about Ms. Cynthia King kicked my door in. She was a co-tenant of a tenant that stayed right next door to my office. I'm in apartment number 4. And she's in apartment number 5. The co-applicant, she didn't reside there, but her blind nephew, I believe, did. Okay, we had an issue regarding some water damage gathered in her place. And at the same time, I'm at work to go over and address her issue. And I went over there and told Ms. King, I don't have a problem her calling on the emergency line, but she only had to call one time and stuff where it goes. I think she called about 5 or 6 times. And I said she only had to call one time. And I just, I went there and informed her that. And then she came and said she can call me anytime she wants to. She was cussing and all,
Judge, I'm sorry, but I think it's 2 devices on or something. I'm hearing the echo.
Yeah, Mr. Cruz, I think you've got 2 devices. If the 2 of you are in the same area, that would.
Okay, sorry about that.
Okay, there you go. There you go. So let me ask you just a couple of questions. How long ago did this happen? When did this happen, Mr. Cruz?
March. It happened March 4th.
2022?
March 4th, 2021.
All right. And you indicate that this, I'm looking at the complaint in this matter. And you indicate that, let's see, just one moment. Yeah, I see your complaint says March 4th of 2021, and you indicate that the damages were in the nature of $350, correct, sir?
100% correct, Your Honor.
All right, so it says, the complaint says that Cindy kicked in the door at the office of Clean Cut on Plymouth Street in the city of Detroit. Is that what happened here, correct?
Yes, that's exactly what happened.
So did you get the door repaired, or did you, how did you know that it would be $350? Tell me about how you got to that.
Yeah, I had to get another door for it, Your Honor. If I could finish just saying exactly what happened, I'll make it short and to the point. But like I said, she said she can call me anytime she wants to. She cussed it and everything too. I didn't say one single word. I went right next door to my office, wrote up a 30-day notice, and gave it to her. Friday goes, and it didn't say no word after that. She immediately after I gave it to her, it was no more conversation as far as I'm concerned, because I gave her a 30-day notice. So I proceeded to walk back to my office because my paper speaks for me. She packed near me, caught me between left her apartment and stuff and said, what you doing this? What you doing this? I just continued to walk away and completely ignored her. She, she tried to make it where I forced her to not let me get in my office and everything, not letting me get in my office. I got an office and stuff. I go. She proceeded to call me a P word, you know, and the lady is like 5'1", maybe about 130 or something. You know, she wanted me to fight her. You know, if I go, she wanted me to fight her. She specifically, you know, loud and cussing, and she, you know, I shut the door on her. She kicked the door in and busted my thing for the door. I had to get another door. So that's basically what happened. You know, my paper speak for me, so I ain't gotta say nothing after that. And I did that. You know, part of goes, you know, and then she chased me down and she got mad because I didn't want to fight her. So I didn't fight her. So she kicked the door in because I guess she said I'm hiding or something like that, wanted me to come out and fight her. That's it, Your Honor.
Did you file any kind of police report or anything like that, Mr. Cruz?
Yes, I did. Yes, I did. I made a police report. Yes, I did. They haven't did nothing. They said what they did was they
Don't tell me what they said, but just I just want to know.
Well, they got some kind of personal thing or something. I guess you know, they didn't some kind of I guess some kind of court thing with it, but you know, nothing really was really done on it. You know, part of those. But I did make a report on it and everything too. And I was just, you know, doing this for damages.
All right, thank you, sir. All right, Ms. Cruz, anything you wish to say at this time, ma'am, regarding this case?
Yes, yes, Your Honor. Yes, I was in the office. Can you hear me?
Her name is Anna Cruz, is that correct?
Yes, can you hear me?
Yes, Ms. Cruz, you were working on March 2021 in the office that has been referred to. Is that correct, ma'am?
Yes, it is.
All right.
And I was in the office and I heard a commotion and looked up and I saw Miss King. She actually pushed Jeff. She pushed him in the back and he came in the office. And I actually told him to just close the door. And then she was outside just fussing, and she started kicking the door, just kept kicking it and telling him to come outside.
And what type of, Ms. Cruz, if you will, what type of door was this that she was kicking on, if you know?
I don't know what type of door. It's a wood door. That's all I know.
Anything else you wanted to say at this time, ma'am?
No, sir.
Mr. Cruz, I want to come back to you before going to Ms. King. What type of door was this and what type of damage occurred, if you will? You're on mute, Mr. Cruz, you're on mute, sir. So unmute yourself.
I'm sorry. Okay, it's a security door gate with a wooden thing on it because people drop their rent in there and I don't want them to see the rent sitting there, so I don't have the glass there. So I had a special made door where, you know, people can put their rent inside the box, but you won't see you won't see it instead of the glass. So it's a regular security door, but I had to make special, and she kicked on that mug and she knocked it out off the hinges and stuff where it goes. And I had to get another one and I already got it already.
So that was the damage, that it came off the hinges, or it damaged the hinges? What or the lock? Go ahead.
Well, the door and it busted the wooden panel off. I did send pictures in that. You know, I did send pictures in, but the busted wooden panel off of it, and jarred it where it had to be replaced. It had to be replaced.
All right. Okay, let me go to Ms. King. Again, good afternoon to you, Ms. King. I know you've been waiting all morning as well. Tell me about this March 4th, 2021 incident, ma'am. Tell me what your take is on this, please.
Okay, good morning, Your Honor. On March 4th, 2021, I have a nephew that's blind, Leroy Stubblefield, that lives in the apartment. I'm his caregiver. I never lived there, but I am on the lease because I have to be able to take care of him. At 5 o'clock in the morning, he called me and said that the apartment had flooded and that he had fallen. He's completely blind. So he said he tried to call the hotline and Mr. Cruz did not answer. So I told him that I would be on my way, and I called the hotline and there was no answer. So then they have an emergency number that you can call also to get straight to maintenance, and I called that number. I called and I explained without cursing. I called and explained that the apartment had flooded, that my nephew Leroy that is blind and had fallen, and that I was going over to the apartment to see if I needed to take him to the doctor. Could he please send someone over to the apartment? That was at 5 in the morning. I got there at 7. The maintenance man came at 10, and I don't know when Mr. Cruz came after that time. During that time, the maintenance man and the plumber came, and they were working on the apartment because the apartment had flooded, and feces and everything was coming from the bathroom all the way to the living room. Dirty water out of the tub in the tub, out of the tub in the sink. Mr. Cruz, they told Mr. Cruz that he would have to that they could not stop it because he needed to do the main drain, unclog the main drain. And Mr. Cruz did not want to pay at that time, so he said he would get another plumber. At that time, he was outside the door. He came into my nephew's apartment unannounced, without knocking, and said to me, if Leroy called, that's my nephew, Mr. Stubblefield's first name. Once he called and said that something is wrong, you don't have to call. I'm his caregiver, Your Honor, and he's blind. I said to Mr. Cruz, instead of you coming into the office and coming into our apartment and saying, apologizing for all this damage, you come in here saying what I should and should not be doing. He said, I have something for you. And he left out. 10 minutes later, he came back into the apartment again without knocking, and he laid a eviction notice on the counter. I went out of the apartment, like he said, and I was trying to reason with him and explain to him. And I said, Jeff, why would you do this to Leroy? You know that he haven't done anything wrong. It's not our fault that the apartment had flooded. Mr. Cruz was upset because he had to pay money for the damages, and he pushed me into the wall. I'm the one that called the police. I'm the one that did the battle, the assault and battle against him. I only had the numbers with me because this happened here when he evicted us. We went to court, and he put in the eviction damage for $350, which it wasn't. The gate only cost $150. I have the canceled check. He took our brand new gate when we moved out, and I didn't even fight him on it because I became very ill with cancer, so I was not able. So the cases just kept on being postponed because I took ill. The case number where it was dismissed is 21240-563, and that was for the eviction, and they dismissed it, Your Honor. He came back after that, and that was on November 5th. He came back on November 17th and had them send me one without my nephew's name on it, with just Cynthia King for the same amount, $350. I did not kick in his door. It is a gate. It is a security gate. It's impossible for me to kick it in because the security gate comes outward. The board that he's talking about that's in front of the gate is just a little piece of board that he sits up inside the gate so that you can't see the mail fall in. It's impossible for me, like he said, at 5-1, being able to kick in a security gate and tear it off and kick it off the hinges. And I am a cancer survivor. And then the reason why I didn't show up for court the first day, because I was in the hospital because my nephew had to go to court for the eviction that was dismissed for the same $350 and the rundown that he asked for all the stuff. He also said that we owed him $1,500 and back rent. That was dismissed because we had paid him $1,600 when we moved in. I know we're supposed to be under oath. I did not kick in his door, and he did not explain to you that the reason was that my nephew was blind and I never lived in an apartment. I just was his caregiver and came over every day to take care of him. I was trying to ask him, would he not evict my nephew? He was locked out of his apartment for 2 days. I had to put him in a hotel because of the damages.
All right, ma'am. So let me ask you, I know that there was a dispute, and you certainly, to the extent that you feel aggrieved by what happened with your nephew, you certainly, if you were damaged there, you have a right to file an action to try to recover damages there. Did you kick that door? I mean, the testimony here is that you kicked.
No, you aren't. No, you aren't. It's impossible. He hit me.
Let me ask you,
I'm
ma'am,
sorry,
did you kick the door?
if I kicked the door, I might have kicked the door. I don't remember because I was so upset because he had hit me and knocked me into the wall. If I kicked the door, I'm honestly going to be honest. I don't remember kicking the door. I went back into the apartment and called the police, called 911. I called the police on him.
All right, gotcha, ma'am. All right, anything else you want to tell me at this time, ma'am?
That he received that when we moved in on December the 18th, 2018, we purchased a security gate, a brand new security gate for $150. And when we moved out, I asked him to return the $150 for the gate, which he never did. He kept the brand new gate and he never returned it. And I took ill, so that I never did try to fight for the $150 because I was in the hospital with going through my treatment and stuff with cancer and COVID.
Wow.
So I didn't. And as far as he's saying the police report, they called me to ask me did I want to go through with the assault against me. And at that time I was in the hospital with COVID and I was deathly sick. And I told them that I was no longer at the my nephew was no longer living at the residence, and that I have no reason to have contact with Mr. Cruz. And at this time, I'm too ill. So I dropped the charges because I was too sick to keep it going, and I was no longer there. So there was no reason for me to keep going on with it. And it was a year later. And and my nephew had already been moved out of the apartment.
All right, thank you, ma'am. All right, Mr. Cruz, you get the last word on this, sir. Anything further you wish to say at this time?
Well, she just admitted that she just admitted that she kicked the door in. So and that's what we're here for. Damage to the.
Let me stop you for a second. She didn't say that she kicked the door in. She said she kicked the door.
Yeah. I mean, that's how it came off the hinges. It didn't come off. You got the pictures of it. It just didn't come off on its own. That's a special made door. It's not a regular one that you get. I had to get a special for it can be able to conceal the rent. And she just admitted that she kicked it. It didn't come off. And and Judge, I'm gonna say something. You know, I've done this for 40 years. My paperwork speaks for me. I give them a 30-day notice. I ain't gotta live with them. And that's all I gotta do. I don't get in no fight with no tenants or nothing else. You know, if I go, I don't rent laws, whichever. That stuff don't bother me. That's my paper speaks for me. She was just upset because she got a notice. You know, she got a notice. She got a notice. She was, you know, in spite of her situation. And like I said, then she cussed me out. I don't want to, you know, she cussed me out now and be like this. You know, the next thing you know, I'm on the news. Some tenant didn't murder me, and I let it pass. I don't never let that pass. You know, where it goes. And I ain't that big on money, but she did actually do damage, and she said she kicked the door. You know, where it goes. You can't get too much more than that. It didn't come off the hinges. You can ask her again after she kicked it. Did the board come off the hinges? She said she might have kicked it. It was physical. It went off of there. You know, I mean, you know, and she a decent person. She just lost it. You know, before I go, she lost it. And she, you know, she said all the reasons why she was upset. So she had reason to be upset and emotionally. But I don't have reason to be upset. You know, far that goes, I have zero reason to be upset. So she just stressed her reasons and said she did kick it. And asked, you know, she, like I said, did it come out the hinges? It come out the board, come out of there. I had to get another door and get the special cap made for it. For like I say, for people can't conceal their rent. It's not a regular door you go by. So you know, far to go, but she did the damage. That's it, Judge. You're really truly.
Thank you, sir.
Your Honor, may I please speak?
Yeah, you don't have a right to again, but I'll give you another opportunity. Talk to me, ma'am. Tell me what you want to tell me.
Okay, Your Honor. The whole thing is, he said that I should have been mad about the rent. I was never late on the rent. I paid the rent every day. Matter of fact, the day before that, I had just paid the rent before the apartment even flooded. He was never late on his rent. He evicted us because he was upset that the apartment flooded. I wasn't upset. He was upset. I had to take my nephew because he was blind and he hadn't had anything to eat all day or his medication, and put him in a hotel. I did not kick his door open. It's impossible. It is a security gate door. You cannot kick in a security gate. It comes outward, not inward. And he is, I don't know why Mr. Cruz insists on saying I kicked his door in. I am 5 feet. I is impossible, and like I said, I am healing from cancer. There's no way I had the strength to kick in a door. I was under treatment for cancer. I can't kick in a door. I can't kick a door off the hedges, Your Honor. And when we went for the eviction, they dismissed it. I gave you the case number. It was dismissed. And that $300 that he claimed was in it for the apartment. He said I didn't clean the apartment and all of that. And the judge dismissed it.
All right, thank you, ma'am. I thought you had something different to tell me. You already told me that. I hear good the first time. So thank you. All right. Last word, Mr. Cruz, you get the last word because it's your burden of proof. If you have anything else to say, sir.
Okay, I'll finish it up. Well, I had two people in the place doing the work, and the door was open, and I just concerned, it's right next door to me. So I had two people physically in there getting her place in order, and just like early in the morning time. So we was on top of her, and as far as any expense that comes involving maintenance, I don't have a problem with that because it's part of the job. So it's part of the job. So any expense that comes with this stuff, it don't faze me not one bit, whether it's little or big. So that's not no major concern about expense we do, because my job is make sure they satisfy at all costs and everything too. But at the same time, they don't pay enough. And she did pay rent every month. But I tell anybody, you can't pay it to disrespect me. You don't pay that much money to disrespect me. If I'm not going to sit there and be thinking I'm going to be dealing with Mike Tyson down the road because something didn't go right. Because if you do it now, it's going to come back later on, and I'm too old for that. So I just, like I said, I let my paperwork talk for me. I can't do it now because of Cobra, but back then, I don't have to. I got to easy out, and I'm not getting no confrontation with anyone. And she's a beautiful lady. And if I put on the record, she's a beautiful lady. She was just overwhelmed there. She's a super lady. I'm gonna tell you about, but nevertheless, she didn't control. She wanted to fight me. I'm not fighting my mama. Part of goes. She wanted to fight me. The lady in the office shut the door because the lady was ballistic. Part of goes and stuff. Part of goes. And she got mad because I did shut the door. That's what made her kick the door. Part of goes. That's it. But other than that, that's it. I said the same thing too.
All right. I've heard enough in this case. I mean, obviously, the plaintiff has the burden to preponderate and to establish that the claim has more evidence supporting it than evidence against it. I've heard the testimony on both sides of this, and I'm aware there's a landlord-tenant relationship that existed between Cruz Clean Cut Management and the nephew of Ms. King. Ms. King was a care provider for that nephew. I'm also aware that Ms. King alleges that as a result of water damage to the apartment where the defendant was living, that she had to move into a hotel and had to move him out of there, and that she incurred some expense there. Clearly, if that's the case, she certainly has the right to bring an action to try to recover damages if she believes that she has a cause of action in that regard. But the other thing that she brought up in this matter was that there was a complaint filed to terminate or to end the tenancy, and that case was dismissed. I believe her, but that case doesn't have anything to do with this case. This case is not about landlord tenant or anything along those lines. This case is about whether or not someone's property was damaged, and if so, what the measure of that damages is, or what the measure of damages are in regard to this matter. Mr. Cruz testified at the very outset that Ms. King was a small lady, that she was about 5'1", but he also testified that she became highly confrontational when he gave a notice indicating that he wanted to terminate tenancy, and when he instructed her that she was not to contact the emergency contact number more than one time. It's okay. People see things differently and they fall out about a number of things and disagree about a number of things. That can happen, but disagreements can never turn into situations where there is physical contact and or where there is contact involving damage to someone's property. You know, the old saying is sticks and stones may break my bones, but words will never hurt. Words do hurt, but words are not enough to really become actionable unless there's some type of defamatory words, and that could be a cause of action. But the fact that there was fussing and going back and forth and complaining and not liking what somebody said, that's of no moment. But when you kick a door, you create a whole nother scenario. And I saw the pictures that were submitted, and there is of course an admission. I appreciate the truthfulness that Ms. King says that she kicked the door. She says it's impossible that she damaged it, but her kicking the door and there being evidence that the door is damaged it provides a sufficient amount of consequential damages. That if you kick the door, that the kicking of the door likely caused the damage that occurred with regard to the door. I am certainly sympathetic to Ms. King being a blessed cancer survivor. I have a sister who's also a cancer survivor. Very sensitive to those kinds of things, and I'm very grateful for the blessing that she has to continue to live, and also the struggle that's associated with being a cancer patient. The struggle that's associated with her uncle being totally blind. All of those issues. Those issues are not central to this particular case. This case is about an unfortunate incident where a door was kicked. Mr. Cruz testifies, as well as Ms. Cruz testified, that it was kicked several times. And moreover, the testimony is that that door was damaged as a result of the kicking of the door. That's all this case is about. There might be other cases that could be filed, but this case is about, was a door kicked? Number one. Number two, was that door damaged as a result of that? And then ultimately, what was the damage if the damage occurred? In this case, my finding is that the evidence is supporting the fact that the door was kicked. That further supports the evidence that the door was damaged. That further supports the evidence that the door required repair or replacement, and that the repair or replacement was in the nature of $350. Under those circumstances, I don't see how a judgment could be in any other direction on this narrow issue. The parties' disputes may have other issues involved. There may be other cases that could be filed, but on this case, where you kick a door, that door gets damaged, the plaintiff is entitled to recover damages for replacing the door. And the damages at $350 is allowed in this matter, together with court costs. My judgment will be for the plaintiff in that regard. I wish both sides well, and I'm signing an order in that regard, and you'll receive it in the mail. Good day to both sides.
Okay, thank you, Chief Judge Coleman.
Not the chief, but thank you, sir.
Not yet, but you going up there. You going up the ladder. Take care.
Thank you, sir. Good day to you.
All right.
This queen person on this Zoom, why are you here, man?
She's on mute.
Yeah, you're on mute.
Sorry about that. I filed I think it was a writ of garnishment because the state portion of my income tax was garnished.
Okay. I called all those cases already. What case number do you have?
So mine's ended in 741. And I've been on the entire time.
Yeah, I've already ruled in that case. I called that case involving Jefferson Capital.
So it was another case that was involved in Jefferson Capital. It was for somebody else. Because it was a different attorney. My attorney was, but the attorney for them was Michael Beach.
Right. I don't have that file, that's for sure. It's on my list. But I don't have that file. And you didn't hear me call that case, right?
No.
So my clerk stepped out for a minute. Let me try to find out what happened there because it is on the list, but I don't have that file, which could mean that it was adjourned or something, but I don't know. I'll find out in a few minutes.
Okay, thank you.
Yeah, she stepped out. She should come back in a couple of minutes. I know it is lunch break. Ms. Spence, you don't know if she went to lunch.
I'm texting her, Judge.
Okay, yeah, check that.
I just texted. She said, okay, she coming back.
Yeah, I have her case on this list, but I didn't call it. Here's the case number.
Okay.
All right, 21-15174.
What's that, Morrow, minor financial?
It's Jefferson Capital.
Give me the case number 21-151.
21-151-741.
Okay, so. Oh, it's a bankruptcy stay.
Oh, okay.
It was a bankruptcy stay.
You filed bankruptcy, correct?
Yes.
Yeah, that's why I did come up today because we got the stay, and that's why the other side's not here because that stops the case, okay? So that stops the garnishment and everything because you filed for bankruptcy.
So no, they took the money though. I didn't get the money. So they told me that I had to file this motion to get the funds back.
That's not true. If you filed bankruptcy, the bankruptcy relates back for a certain period of time. So the bankruptcy will relate back to the funds that they took, and they got to get those funds back to you. Once you file a petition in bankruptcy, that stopped the entire case here in this.
So the funds were garnished in early March, and I contacted the treasury and they told me to do this. So how would I go about where?
Wow, here's what you got a lawyer in bankruptcy?
Yeah, but they told me that I would have to pay extra money. So when I came down to 36th district, they said that they were able to take the funds because the discharge of bankruptcy wasn't turned in. So I turned it in on the day that I filed the motion, and they told me that this court hearing would be for them to return the money to me.
That's not how it works. If you got a discharge of bankruptcy, that stops everything here. There's nothing there. That's why the other side is not here. And that's why I only have a file on it, because I received in the file a stay. That stay stops the case here. So you have to talk to your bankruptcy lawyer to find out what you need to do next, because the bankruptcy stopped everything here.
So I did, and that's why I'm here today. So when I called my attorney.
We're not gonna go back and forth talking about that over and over again. And you gotta hear me and hear me clearly. I'm not trying to be mean to you. I can't do anything because of the bankruptcy. Bankruptcy has control over this court. When it is a debt involved, anything like that, the bankruptcy stops everything here. That's the problem with this. Otherwise I'd be calling your case. I'd be glad to deal with it. The bankruptcy ties my hands on that. That's all I'm telling you. Now, notwithstanding what somebody else may have told you. I've only, I don't say this to try to be funny. I've only been a judge 30 years, and I know how those things work. And that's unfortunate that somebody's telling you one thing or the other thing. What I'm telling you is what I know to be the case is that bankruptcy deals with this entire case. It stops the case in district court. That it ties our hands. Now, whatever they're telling you, they gotta file something to correct that, because otherwise there's nothing that I can do with this court. There's nothing I can do with this court.
So you're saying to reach out to the attorney?
I think that you got to talk with your bankruptcy attorney.
I did. That's what I'm telling you. The bankruptcy attorney told me to do this.
Yeah, that's stupid, for lack of a better way of putting it. So maybe you want to reach out to the other side as well. I don't know what you need to do at this point. I just know that with the bankruptcy filing, that bankruptcy filing made a determination that stayed this case. That's what this case is. This case is stayed. And they're wasting your time by sending you here. And that's why I'm not frustrated with you. They're wasting your time. You sat in here all morning long. And somebody should have told you, particularly your bankruptcy lawyer should have told you that you don't have any business over here because of the bankruptcy petition. That's not anything that's bad. There's a way for that bankruptcy to relate back to funds that were taken within 60 days of the filing of the bankruptcy. So even if, for example, if the bank garnishes my account and I file for bankruptcy, that bankruptcy relates back to the last 60 days. Likewise, if they garnish some of your money and you file bankruptcy, it relates back to 60 days prior to the filing. And so you should be able to get your money back, but that's the order of the bankruptcy court. All right.
Okay.
So
I sent her her copy on 28th, you signed it, so I sent her her copy, so she probably could sit on that.
Yeah, did you get a copy of the bankruptcy stay that I signed?
No, I didn't get anything.
On 29th.
She sent it on the 29th, so you haven't gotten it in the mail. You'll get it, mail's a little slow. You'll get it in the next couple of days. And that stops anything that I can do in this case because of the bankruptcy. That's the way I don't expect you to understand all of that because that's that has a little bit of complexity that lawyers know about, but I don't expect you to know that. I'm disappointed that somebody is giving you some information or advice that is not correct. Now, as long as you're dealing in bankruptcy, that stops everything.
And that's what they said. And when I told the attorney, I explained to him the same thing I explained to you, because I think they filed for their garnishment in August. I filed the bankruptcy in November of last year, and then they garnished the taxes in March. So he said that this was the process to get it back, or I had to pay him like $500 more to fix whatever went wrong. And I didn't see that being my fault.
And that's crazy. So yeah, that's not your fault. And that's crazy. So the thing that I got acts as a stay. Do you still have an open case in bankruptcy?
No, so I got my order of discharge, I believe, on February 9th.
Okay.
And I turned that in with the motion and everything that I did for this hearing.
Yeah, well, if you got a discharge, that discharge should wipe that out, not only before, but after. Because the discharge puts them on notice, it puts them on notice anyway. So you need to send it to whoever took your money. You need to send that to them and notify them of the same, and then notify, even if you have to do it yourself, notify the bankruptcy court that they will not return your money to you. That's all of that
Okay,
stuff.
so how would I go about notifying the bankruptcy court?
Whoever the judge is on that signed your discharge, look on your discharge, and whoever signed your discharge, that's who you want to provide the notification on. You're saying that
Okay.
the debt that you had was discharged in bankruptcy, correct?
Yes.
Yeah, so they have no business collecting anything.
Okay.
Right. All right, I wish you well, ma'am. I wish there was something else I could tell you, but I don't want to tell you something that's not true, because that ain't gonna help you, you know.
Right.
And,
Thank you, Your Honor.
All right. I wish you well. All the best to you. Okay.
Thanks, I'm new.
That was a big day. Yeah, that was a big day. I
got you.